Welcome to Tompkins Talks. It's time for another short, snappy summary of a recent case in a format that's easy to digest, whether you're at home, in the office, or on the move. Now, I'm sure lots of you thought that I was going to talk about two cases that have come out in the last week concerning tenants' COVID defences to landlords' rent arrears claims, where the landlord has succeeded on both. I'm going to save those for another time, but if you want to read about them, please do check out these excellent articles on our website. In the meantime, what I want to talk about is a case that concerns lease renewals in this new world we're all living, and it's this case of WH Smith Retail and Commerz Real Investment Gesellschaft. So let's get started with the backstory. This case concerned the lease renewal of WH Smith's premises in the Westfield Shopping Centre in Shepherd's Bush. Now, by the time the matter came to court, the vast majority of terms had been agreed between the parties, including the fact that the lease should include a pandemic rent suspension clause. However, the trigger for that suspension was not yet agreed. The landlord's position was that the suspension should only apply if WH Smith was required to cease trading, whereas WH Smith's position was that it should apply when non-essential retail was required to cease trading. Now, this was a really important distinction because actually this particular WH Smith had been able to trade for the vast majority of the pandemic due to the fact it was seen as essential retail as it had a post office in the branch. One of the other key facts to be decided by the court was whether any additional sum should be added to the rent to take account of the lease including this pandemic rent suspension clause. The landlord was arguing that their rent should be increased by 10% to take account of this clause being in the new lease. So what was the outcome? Well, the county court judge found in favour of WH Smith on both points. He held that if the landlord's trigger for the rent suspension was used, it would mean that effectively WH Smith would never benefit from a rent suspension because it would be seen as an essential retailer due to the post office and would not close. On the rental uplift the landlord was seeking, the judge simply said that should not go into the lease. The fact was, as he saw it, the clause was trying to share the burden of loss caused by the pandemic, and this type of clause was something that all tenants expected and the market had priced in. Now that's quite a statement, isn't it? The judge was saying there, every tenant expects there should be a COVID rent suspension clause and the market has now priced that in. So what does this mean? Although this is only a county court decision, it's a great one for tenants to refer their landlords to on a couple of points. First, leases should include pandemic rent suspension clauses, and the trigger for those clauses should be the closure of non-essential retail, whether that particular tenant's business has to close or not. Second, tenants should not pay any more for having a pandemic rent suspension clause. The judge in this case said it's what the market expects, and that's what tenants should be referring to. A couple of other things to highlight, as set out within this Grocer article that's a good read. It makes clear that actually in every Section 26 request that WH Smith is serving now, they are proposing a COVID rent suspension clause because they say it represents the open market. And it certainly appears other retailers are doing this. Poundland, for example, are referred to within the same article. If you found this video useful, please comment, like or share. I'll see you again soon for another Tompkins Talks.